which green card cases inside the United States are most likely to be affected by this new policy and which ones may not be. Hi, I'm Christina, here to help you navigate US immigration. And this is part 3 of our discussion about the new USCIS Adjustment of Status Memo. Today, let's talk about the question everyone is asking right now. Which green card cases inside the United States are most likely to be affected by this new policy and which ones may not be? And the most important thing I need to say first is this. Right now, nobody has all the answers. USCIS has not released a list of protected or exempt categories. And immigration lawyers across the country are still trying to figure out how aggressively this memo will actually be applied in real life. But based on the memo itself and discussions within American Immigration Lawyers Association and what attorneys are already starting to see at interviews, some patterns are beginning to emerge. The cases most likely to be affected appear to be the traditional adjustment of status cases, especially marriage-based green card, employment-based green cards, tourist visa entries followed by adjustment of status, ESTA entries, overstay cases, unauthorized employment cases, and cases involving prior status violations or complicated immigration history. Why? Because these are the exact types of cases where USCIS officers now appear to be focusing heavily on discretion, meaning not just are you legally eligible, but also do we think you deserve approval? And attorneys are already reporting officers asking new types of questions at interviews, including why didn't you consular process abroad? Why did you stay after your status expired? Why are you applying inside the United States instead of from your home country? Do you still have family abroad? Historically, those questions were not central in many standard adjustment of status interviews. Now they may become much more important. But here's where things get complicated. There are also many categories that may be treated differently, especially humanitarian-based categories. For example, Violence Against Women's Act, U visas, asylum-based adjustment, refugee adjustment, special immigrant juvenile cases, and similar humanitarian or special statutory categories. I certainly hope that these categories may be less affected because Congress created them with very specific humanitarian protections and policy goals. But, and this is critical, USCIS has not officially confirmed that these categories are exempt. So, right now, attorneys are operating in a world of uncertainty. What we know is that USCIS clearly is signaling tougher discretionary review in many adjustment of status cases. What we do not know is how far USCIS will try to take this policy, whether humanitarian categories will truly be treated differently, whether field offices will apply the memo consistently, and whether federal courts will eventually limit or block part of this policy. So for now, the safest approach is this. Treat every adjustment of status filing as if USCIS will carefully examine not only eligibility, but also the entire story behind the case. Because this policy may fundamentally change how green card cases inside the United States are reviewed moving forward, and we are still only at the very beginning. Stay tuned for part 4 coming up very soon.